Do you see it?
Yes, I do.
So what General Mkhwanazi says here, what he says here is in the context of the meeting, of the Pearls meeting. He says, that's when he gave me this information. The information is about Steve Mutsumi. Steve Mutsumi. It is a name that the 68 million people, excluding the independent podcasters, are the ones who have the guts to talk about. The rest of the media houses, it says mirror houses, but I think it meant to read media houses in South Africa, do not want to research that person. It's a name that has come out so many times, Steve Mutsumi. He told me about Steve Mutsumi. He gave me the address of the house of Steve Mutsumi. He told me about the activities of Sibia, how Sibia is collecting money. He told me about the property of Sibia that I did not know. He gave me the address. He told me about the imbalances. I think there too, what was meant to be the imbalances is meant to be impalas. He bought for Sibia. This is all coming from Cat voluntarily. I do not have a clue about all these things. The properties in the townhouse, I think he meant the properties and the townhouse in, and then it says Sentinel, but I think that's meant to read Santon. Okay, did you follow that?
Yes, I did.
What discussion did you have with General Mkhwanazi about Mr. Mutsumi?
Like I said before, Advocate, that this is something that we are going to contest in court, so I'd rather not comment on this thing.
Okay, can I ask you this? Did you speak to General Mkhwanazi about Mr. Steve Mutsumi? Just yes or no?
I was asked the question, yes.
I think his answer was, I was asked a question.
Yes.
Okay, let me clarify that answer. When you say you were asked a question, who asked you the question?
General Mkhwanazi.
What did General Mkhwanazi ask you?
We're talking about Mr. Steve Mutsumi.
But what did he specifically ask you? Did he say to you, do you know this person, or what?
I don't have a way to explain it to you because I will end up disclosing as part of our defense strategy. So this is a crucial part of which I think it led to my arrest, like I explained before. So I do not want to comment further on this part.
I want to understand your objection to answering. Are you saying that if you don't, that if you answer the question, you will incriminate yourself?
No, not incriminate myself. I'm saying I will.
So what right are you relying on not to answer? And we just remember we've had the conversation about.
Yes, yeah. I still have to present my case in court. And then this is a very crucial part of how I want to present my case in court. So disclosing this part is, yes, it won't incriminate myself, but it will be beneficial for me because it will explain how things unfolded. So this is the reason why I'm saying I do not want to comment on it, not because it's going to incriminate me. Yes, it's not going to incriminate me.
It will not incriminate
you.
But then I think, Mr. Matlala, I have to ask you to answer the question. And the question to you was, your first answer to me was, yes, you spoke about Steve Mutsumi. The second the second answer was that you spoke about it because you were asked about him, and that it was General Mkhwanazi that asked you. And then my question, which you now don't want to answer, is what was General Mkhwanazi's question about Steve Mutsumi? Right?
Yes.
You've got that.
Yeah. Yes, Ms. Oh, are you done?
No, I see my learned friend wants to interject.
Yes. Chairperson, at this stage, I think it's that moment where I need to address you on the issue of the client is. Let me start there. Mr. Matlala has made it clear to you that he does not wish to disclose defence strategy. In terms of the provisions of Section 35, an accused person has the right to challenge evidence in a court of law, and part of that challenge of evidence in a court of law has got to do with litigation privilege, of course, the manner in which you present your case, the credibility of witnesses, etc. And I think in his own way, that is what the client is endeavouring to say. For me to disclose to you here why I don't want to answer those questions is going to be me disclosing defence strategy in my case. It relates to his arrest. It relates to the manner in which the arrest was effected, the reasons for the arrest. In other words, was it a lawful arrest? In other words, it's a challenge to the lawfulness of the arrest. These issues, if you can recall, he has dealt with in the supplementary affidavit. The events that unfolded after that relates to the statement that was made, the lawfulness of how that statement was obtained, the failure to afford him an opportunity to have legal representation, the fact that he was questioned without giving his rights for, I think, about 8 hours during the whole process. And I respectfully submit that this is one of those crystallized constitutional rights that an accused person has in law. Thank you, Chairperson.
Ms. Hassan.
Chair, this is a very broad and generalized assertion of a fair trial right. I hear what my learned friend is saying. Some of these points were raised in the supplementary affidavit by Mr. Matlala when they first sought to interdict the questioning. I wish to say the following. The first is, this is not a criminal court. It's an investigative commission. Mr. Matlala, in these proceedings, is not an accused. He's a witness. And an implicated witness must receive a fair opportunity to know, answer, and test material, and for us to be able to test evidence with the witness. It doesn't confer a right on the witness, the rights that my learned friend seems to be trying to advance should be protected here. It doesn't confer a right to suppress disputed material. The objections are about the search and seizure, unlawfulness of the arrest, and all of that. I think that what Justice Jafta made clear, and I just want to go to the paragraph directly, because there's an assumption, I think, that Section 35, as a fair trial right, is available to a witness in a commission simply for the asking. The minute you say, well, it's a Section 35 right, then it may be available in the commission, and that's not the case. So, for example, the submissions my learned friend makes about evidence that was obtained unconstitutionally, and I think that's in Section 35(5) of the Constitution, is not something, it is something that he may assert in his trial in due course. It remains available to him to do so. But it's not something that can be asserted here as the basis for not answering a question. And so it's paragraphs 90 let's start at paragraph 90 of the Justice Jafta judgment in the Zuma case. And what
is the difficulty, though, not this? There's the question of derivative material. He testifies, fine, this is not the criminal trial, but who knows, subs, prosecutors, and everybody are either listening or, like everybody else, will have access to the transcript. Hence, my reference to derivative material, and based on what they derive from that, that may then be used against Mr. Matlala. Then hence the argument about unfairness of the trial eventually.
Well,
Fine, the trial will be down the line. This is not the trial.
Well, but
Yes.
it is for the trial court to ensure the fairness of the trial. And so if that were to eventuate, and remember the scheme of the Commission's Act rules and regulations is you've got to answer questions barring your privilege that exists under Section 3(4) of the Commission's Act. Any question that you answer that is self-incriminating may not be used against you. But yes,
Why
we know
Why
from...
does that same reasoning not apply to that privilege then? That is, yes, the 1947 Act, there was no question of the Constitution because it was simply not there. But the witness is afforded the right to assert the privilege.
Yes.
So now that we have the Constitution, why can't a witness similarly say, but I have this right, and
Well,
that bears relevance to the trial. And why you assert the privilege is exactly because it bears relevance to the trial. So my point is, analogously, why is it that you cannot raise your fair trial rights here before the Commission?
Well, let me say this, Chair.
So the answer, sorry, so I'm very sorry to interrupt you. The answer cannot be, that's because it's not in the Commission's Act.
No.
Yes,
No.
yes.
And I hadn't completed my submissions on that. It's the Commission's Act is the starting point. The Commission's Act has, of course, been interpreted. And that's why the Justice Jafta judgment is so important, because it is testing the provisions, and it's in the context of an inquiry. And we know that this is a crystallization of the theme of the privilege against self-incrimination that started with Ferreira versus Levine. But let's not go there. Those were other contexts under the Companies Act. But what we know that the case law has made clear is that you have a privilege. If you answer, can't be used against you. And of course, there's this derivative evidence issue, which is if investigators independently find out information, then they could bring it to a trial. My argument is that part of the derivative evidence would be something for the trial court to control. It can't be something that prohibits this commission from its fact-finding mission and from the truth-seeking mission that's incumbent upon it. And so the Section 90 of the Justice Jafta judgment it's quite plain. And
Paragraph?
Paragraph 90.
90.
90. Where he says, let me just say from the beginning, he says, although clumsily put, it is apparent that the respondent and his legal team believe that he has a right to remain silent during proceedings before the Commission. However, the right to remain silent that I am aware of is the one guaranteed by Section 35(1) and sub 3, 35 sub 1 and sub 3 of the Constitution and under the common law. But that right is evidently available to arrested and accused persons only. When he appears before the Commission, the respondent's status is that of a witness. He is not an arrested person, nor is he an accused person. Moreover, a witness in a criminal trial has no right to remain silent. And then he explains why there are cogent considerations that militate against permitting witnesses to invoke the right to remain silent. And really, Chair, that's the point I made. I'm not going to go into and read it. It's there, it's the Magidwana judgment, but it's the point that I'm trying to make, which is what is the function and purpose of this commission? And the truth-seeking function is why we are here. And the effect of what Mr. Matlala's legal representatives are submitting is that it will close this commission off, and for other witnesses too, who are still to come, from large parts of evidence that you would not have access to. So we have to distinguish between the commission and the proceedings in the commission and the later trials and the duties on the trial judge to ensure the fairness of that trial. I don't know whether, well, let me address it, because my learned friend referred to the evidence that was obtained. If I didn't hear that correctly, then I won't go into this. But I thought that was part of the reason for asserting the right, is the question of unconstitutionally obtained evidence, including through the search and seizure and the seizure of the cell phones, and then statements and recordings that were taken.
I think, Ms. Vandenhoefer went far wider than what we were dealing with, but I guess she did so because it's a point that she has been touching on repeatedly. But I guess it's useful that we deal with all of those issues at once.
That's right, Chair.
Yes.
I think that it's an issue that's cropped up
Yes.
before. And I understand that my learned friend's interjection now was to say, let's deal with this once and for all. So let me address the full scope of her submissions then. And so on the aspect of the evidence and the material that you are entitled to have reference to, what we know from the law is that the Commission is permitted to receive and to consider a wide scope of material. And we know this, of course, from the Sparks case, which was a pre-Constitution case, a 1980 judgment, but that was the one which said that a commission, an investigating commission, can have regard to any material in any way it finds it. Newspaper reports and even hearsay evidence. That was the Sparks judgment. It was a pre-Constitution judgment, but it has been upheld in numerous cases since then. And of course, one of the cases in which it was upheld was the Bongoza case, which you know very well, Chair, because you appeared in that case. And as life would have it, you appeared before Justice Jafta.
And if I were to blow my own horn, I was on the winning side.
And what Justice Jafta held in that case is that the commissioners are not required to follow and apply rules of evidence as they are applied in courts. The standard is much more flexible, and what is fair to a witness in a commission is not the same as what may be fair in a court hearing. And then my final point on that, and why I think we then get to 6.1, Rule 6.1, because that reflects, while I've heard the Chair's point about the 47 Act, the regulations and the rules.
That was just testing your argument, that's all.
Okay. I hope I've addressed.
No inclination one way or the other, just testing your argument.
I think, Chair, thanks, Chair. I've noted that the law that I've referred to now is encapsulated in Rule 6.1 because it makes it clear that the Commission may receive any relevant evidence, including evidence that might otherwise be inadmissible in a court of law. So, to the point about the unconstitutionally obtained evidence, you are entitled to have regard to that. The trial court will have to determine whether indeed that evidence was unconstitutionally obtained. But in fact, if we read 35.5...
It then has a discretion right at the end of the years, whether
it will render the trial unfair.
Yes.
So it's not an automatic exclusion. And so if it's not an automatic exclusion in that court, it should not be an automatic exclusion before this Commission. So those are that's my response to my learned friend.
Also, I think in the evidence leaders' written submissions, you make a point which I found quite attractive, which was the Commission does not have to reject the evidence, but rather must assess its cogency, I'm paraphrasing, based on everything, which may even include the very fact of the unlawfulness of how it was obtained, but weighing everything, taking everything into consideration, but not just rejecting on the basis that the evidence was obtained.
Indeed so, Chair.
illegally.
It will be probed, it will be tested, it will be weighed, and it will be weighed in the context of volumes of material that are relevant to that question, but also what is relevant to it is what the witness has to say about the particular topic or the particular piece of evidence we're dealing with. That's something that the Commission, too, should be able to weigh up.
Professor, specifically on paragraphs 90 and 91 of Jafta J's judgment, which was a unanimous judgment of the Constitutional Court.
Thank you. Let me start off by stating the following. At the time this judgment was delivered, Zuma was not appearing at that point before the Zondo Commission, as it then was, as an accused person. So he didn't have the rights of a suspect or an accused person to assert. If you go to, I think, paragraph 111 of the judgment, Justice Jafta makes it clear that the decision that needs to be decided before him, if you bear with me, he says, the real disputes about the respondent's attendance at the Commission hearing for purpose of testifying and answering questions lawfully put to him. So his whole issue was that he believed at that point that as a witness appearing before the Commission, he could assert purely as a witness the rights that's afforded under the Constitution to an accused person or to a suspect. And the issue of the suspect, of course, we know, I think it was the judgment, it's in the Gauteng division where Judge Catherine Satchwell made delivered judgment to say that those rights that's afforded to an accused is also afforded to a suspect. So that is against that background that we need to deal with the Jafta case. I've yesterday touched on the situation where I said to you, I do not believe that, that the moment that your rights that's afforded to you under Section 35 as an accused person suddenly cease just because you're called to become a witness before the Commission. Because if that were to be so, those rights would be meaningless and would become a nullity down the line. In the SCA matter of State versus Magwaza, Pon and J.A., where the majority said that it's clear that the rights in question exist from the inception of the criminal process, that's from arrest until its accumulation up to during the trial itself, etc., etc. Now, I take it one step further, and I respectfully submit to you, there is absolutely no indication. I could not find a single case that says that if the opportunity arises where you should and can assert those rights, that you are not afforded the opportunity to assert it just because you're not in the criminal process itself. We can, and I think the whole issue, or the point that we're trying to make to you is that we've got certain fair trial rights. And part of your fair trial rights, as I said, that it's been crystallized over a period of time, and I addressed you quite a bit on it already yesterday, is that part of your fair trial is your litigation privilege that you hold. It means that you cannot be compelled to ahead of time make disclosures about how you're going to defend yourself, what you're going to, the manner in which, for instance, you're going to deal with certain evidence, etc. That's but one aspect of it. My learned friend has addressed you on the issues, for instance, of the recordings that were made. And what we hold dear about that particular aspect is you want to put a reverse onus on us and by you, again, with respect, I mean the royal you, by saying there's now a reversed onus on you. You now have to assert certain rights before the Commission, an onus that you would never bear in a process where you are actually accused, to now come up with a reason why you should not answer, for instance, why certain recordings can't be used against you. In a trial, and I say for purposes of this commission, the same point will stand. You've got the right to say that before you can rely on a recording, or before you can force me to answer questions about the recording, I'm saying to you that I've got a right to challenge the lawfulness of this recording, and part of it relates to whether my Section 35 rights were adhered to when you made this recording, or when you forced me to answer these questions. And part of that goes back to the issue, if you withhold a person his right to a legal representative and you question him for hours on end without giving him food or water, you infringe his right to with regard to the lawfulness of the statement you then wish to rely on. So what we say in that regard is, you want to now force us to answer questions about a statement where we believe we can prove beyond a reasonable doubt that statement was unlawfully obtained. But because it's the commission and we now regard it as a witness, we now forced to answer those questions without asserting our rights when it comes to that particular issue. I want to go to the section that my learned friend referred to. If you look at what paragraph 90 says, it says, although clumsily put, it is apparent that the respondent and his legal team believes that he is a right to remain silent during the proceedings before the commission. However, the right to remain silent that I'm aware of is the one guaranteed by Section 35 sub 1 and 3 of the Constitution and under the common law. And then he goes on, he says it's a right to an accused person. Now, I respectfully submit, until such time as there is a judgment that rules to the contrary, I do not believe that the judgment of Zuma and that Mr. Justice Jafta, in the decision that he made then, said that those rights are not afforded an accused person when he appears before a commission, that those rights are taken away from him just because he becomes a witness before the commission, that he cannot exercise those rights before the commission just because he's a witness there. I respectfully submit that if we read what he said here, even what he says in paragraph 19, he recognized the fact that a person that appears before the commission would have, if he is an accused person, the rights that is afforded under Section 35. And in fact, I go so far as to say that even yourselves, in your rules and your regulations, recognize the rights afforded a person in the Constitution when you deal with the issue of subpoenas. It's clear, it's almost a copy and paste out of the rights that one is accorded when you get served with a subpoena, a search or a seizure subpoena. So I respectfully submit that where the Constitution is the Supreme Court of this country, I do not believe, and I don't believe it was ever the intention, to take away a person who is rightfully recognized as an accused his Section 35 rights just because he now appears as a witness before the commission.
In paragraph, let's look closely at the wording of paragraph 90. It says, when he, that is the witness, appears before the commission, that was the respondent in that case. When he appears before the commission, the respondent's status is that of a witness. He is not an arrested person, nor is he an accused person. So when he is before the commission, he is not an accused. Even if the witness may be an accused before the criminal court, but before the commission, the status is that of a witness, says Justice Jafta in so many words. He is not an arrested person, nor is he an accused person. Moreover, a witness in a criminal trial has no right to remain silent. But I just focus on the two or so preceding sentences.
Yes.
Yes.
Sorry, Chairperson. I understand what Chairperson is intending to convey to me. I, however, say you need to read what he says here, Justice Jafta, in light of what transpired before him. He did not have an accused person or a person as an accused person who asserted those rights. The then President Zuma was merely a witness, and he tried to assert an accused person with Section 35 rights just as a witness. The situation that you're now dealing with, I respectfully submit, is completely different. You now have an accused person who might coincidentally also be a witness before you. And the mere fact that he is a witness, I respectfully submit, does not take away the rights that he's afforded under Section 35. Those rights, I respectfully submit, has found its being and is there, is crystallized and spelled out, and then of course developed through case law for a very good reason. And I respectfully submit, I've not come across a single case that says those rights are only afforded to a person when he's an accused in a criminal trial. I respectfully submit many of those rights are asserted by people outside of the specific situation where he is directly dealing with being an accused or being a suspect. In other words, not necessarily in the situation where he is an accused. And my submissions to you, and I've made further submissions to you yesterday, I don't want to repeat all of it, is that until such time, I respectfully submit there is, let me go, I'll backtrack that. I respectfully submit that I do not believe that the Zuma judgment takes away the rights of an accused person if he is an accused, recognized, or a suspect person, or any of the other rights that are asserted. If he can indicate and demonstrate to the Commission that he has those rights because he is an accused or a suspect, or he wishes to challenge that evidence, when he appears before you, even as a witness, I respectfully submit he can assert those rights.
Two questions. The first one is in relation to the question asked, which is what did General Mkhwanazi ask? Was that the question? Yes. What is Mr. Matlala charged with in that regard? For your argument to make sense, because you are saying he's an accused. So he's an accused charged with what in relation to that question?
My understanding was he does not assert the right because he's an accused, and in a criminal context, if I answer it, I will incriminate myself, or I have the right. My understanding from what he said...
Then that would destroy your argument. That would destroy your argument because you are distinguishing his case on the basis that he happens to be an accused person, and therefore his situation is distinguishable from that which the Constitutional Court was dealing with in the case that we are focusing on.
May I complete my submissions to you, please, Chairperson?
No, I think this will actually...
Yeah, so what I'm saying is, his submission is, I'm an accused person in a trial, and I've got litigation privilege, I've got a strategy that I wish to deploy during that criminal trial as an accused person.
How does that criminal trial relate to the question that was asked? That's my question. What's he an accused in respect of, insofar as the question that was put by General Mkhwanazi to him was? Because otherwise your argument falls flat, because paragraph 90 and paragraph 91 will stand. It doesn't stand on your argument because you are distinguishing Mr. Matlala's situation. You are saying he is an accused, which was not the case in the Zuma case. So I'm saying, show us, I'm not saying he is not, I'm saying show us how he is an accused person in relation to the question that was put to him by General Mkhwanazi. Maybe you have an easy answer to that.
Chairperson, yes. He yesterday indicated to the Commission on a question, I think, I'm not sure, one of the Commissioners might have put it to him. He said that when it comes to what transpired, it could even have been the day before, when it came to what transpired at the polls, that he is currently an accused. It relates directly to the charges that he's facing in Johannesburg. And if you can recall, I think he gave evidence on the last Monday when we were here. He said, at that point, General Mkhwanazi told me that I'm an accused person, I will be arrested. And he then went on to explain, but I do not want to deal with this further because what else transpired there is directly related to the case that I face in Johannesburg. Can I just
And you say that was yesterday. I'm not sure, if you're talking about yesterday, I'm not sure how, if at all, that relates to the questions being asked by Ms. Hassim right now.
It was...
Just a minute.
Chairperson, if I might just continue. So you
Yes,
will recall when I was addressing you, I said, and in fact I addressed you on it the last Monday, and that is when this issue raised. I've indicated to you then, part of the whole case that Mr. Matlala is facing in Johannesburg, and that can be objectively established from the day he first appeared there, it was placed on record. He challenges the lawfulness of his arrest. He challenges the lawfulness of his further detention, and part and parcel of that whole arrest is linked up to what transpired at the polls. In other words, why he was arrested and why he's facing the charges that he is facing. Number two, the same submissions, as I said, goes for this, what we submit is an unlawfully obtained recording, as well as the rest of the defenses as it folds out, because it all emanates from the moment of the arrest that what we submit was an unlawful arrest. So everything that happened from there, it's almost, it goes back to the, I know the Americans like to use it, we don't use it there, but for ease of reference, I'm going to, it's the fruits of a poisonous tree argument, and that is part and parcel of your defense strategy that you've got and that you can use and you can implement, and it's part of your rights to challenge evidence and to adduce evidence. And if we are forced, and by we I now mean the royal we, if we are forced to now go and disclose the manner in which we intend to prove why we say we were unlawfully arrested and detained subsequently, and how this whole thing unfolded, we can just as well now, Chairperson, Mr. Mkhwanazi, Mr. Matlala can just as well now sit back and tell for everybody and anybody to hear exactly what's going to happen in the trial. And this, with respect, it comes back to what you said. It's a derivative evidence rule. It's applied in the Canadian Commission's situation. It's applied in Canada. It's applied in Australia and in England. And we know it's one of the biggest criticisms that there is of commissions, is the fact that derivative evidence is very often used to prevent a strategy down the line for people who later on appear in courts because of what has happened before a commission.
Do you know what would actually assist us to know if Mr. Matlala is actually an accused, which is the font of your argument or the springboard for your argument? It is this. An answer to the question put by Ms. Hassim, which is, what was General Mkhwanazi's question to you? That's going to tell us what all of this was about. And then it gets easier for us to know whether or not he was indeed an accused person. I'm not at this stage. I'm just engaging you on your argument, because you are saying this judgment is distinguishable because there we are not dealing with an accused person. And when I ask you the direct question, okay, tell us what exactly Mr. Matlala is an accused in respect of, I'm not sure that I follow your response. I'm not sure. You are giving us generalized answers which do not say. In relation to that question, which you are putting to Mr. Matlala now, Ms. Hasim. Mr. Matlala is actually an accused person. In relation to that very, I've not heard you say that. Now, I'm saying, and in fact, I'm going to actually, I'm inclined, let me upfront say that, I'm inclined to overrule the objection insofar as it relates to answering just the question, what was General Mkhwanazi's question to you? I just do not see how that can ever affect Mr. Matlala's defense. Thereafter, I have no idea what will flow from the question, in fact, in particular, from Mr. Matlala's response. I just do not see, unless you show me, you show us how that a response to what was the question about, that has nothing to do with the rest of what then flowed or followed from his response to that. I just do not, unless you show me how. And I hope the response will be brief.
Yes, Chairperson. The fact of the matter is, the fact that you are an accused person in a trial affords you all the other rights under Section 35.
I've heard that.
Chairperson,
I've heard that. Yes.
But Chairperson, with the
Yes.
greatest of respect,
Yes.
if I'm an accused in a murder trial, I am afforded the right to challenge evidence and adduce evidence. I have the right to challenge the lawfulness of my arrest or not. I don't need to be before you with the greatest respect as a witness. Evidence and adduce evidence. I have the right to challenge the lawfulness of my arrest or not. I don't need to be before you with the greatest respect as a witness now say, because I've already indicated, I'm an accused person in the Johannesburg case. The fact that you are entitled to challenge under 35 certain evidence, to exercise your rights under 35, does not need to be related directly to a specific charge. The charge is there, he is an accused person. That's accepted by everybody. So you don't need to your specific challenge that you launch. And the reason why you don't want to...
But Mr. Matlala is an accused person in respect of something specific or issues that are specific. So the direct question has been, insofar as this question is concerned, does that relate to anything that he is specifically charged with? It cannot just be the broad question that he happens to be an accused person.
Person, he said to you, I am charged as an accused person in Johannesburg with various offences.
That says nothing. Are you done with your submissions, or at least on this point? Just on this point? Because my inclination, my indicated inclination, are you done with your submissions on it? My indicated inclination, which is that my inclination is to overrule your objection insofar as it relates to the question and an answer to it. That's what you are responding to. Yeah. Yes.
Sorry, Chairperson, if you do wish to overrule us, I'm going to ask you with respect, if you can please explain to us why, so that we can understand the reason why you...
I already did when I indicated my inclination. I said, I just do not for the life of me see how responding to a question that asks, what question were you asked? I do not for the life of me see how that will impact the rights that are being asserted. There it is. Are you done with your submissions then?
Just one last thing, Chairperson.
Yes,
if
yes.
you wish to assert a specific right, and part of that right is to challenge the evidence of a witness that's directly related to the reason why you arrested or not, I respectfully submit that gives you full reason not to answer this question.
Thank you. Thank you very much.
Chair, I need to say something because I need to correct something.
Oh, all right.
And so it's important for me to have an opportunity to address you very briefly. The first thing is on the question of an accused. Mr. Zuma was an accused at the time he was appearing in the Zondo Commission. So it's not correct to say that he was not an accused. The second thing I wanted to correct is that Ms. van den Heever relies on the judgment of Justice Satchwell, and I believe it's in the Sebian case. Yes, right. So what that case assists my learned friend, so she relies on that, but she doesn't tell you that there are other cases that take a different point of view from Justice Satchwell. And